Stephanie, could you do a roll call for us?
Yes, ma'am. Board Member Burns,
Here.
Board Member Caldwell. Here. Board Member Pastor Jones,
Here.
Board Member Fay. Here. Board Member Pastor Nathan,
Here.
Board Member Grove,
Here.
Board Member Jackson,
Here.
Board Member Strickland, and Board Member Younger. Dr. Ford did say he would not attend today.
Thank you, Stephanie. All right, welcome. Hopefully, everyone has had an opportunity to look at the minutes from last month's meeting. Does anyone have any edits, additions, or corrections? Seeing none, would anyone like to move to accept the minutes? Thank you, Board Member Younger. May I have a second? Thank you, Pastor Nathan. All right, all in favor of accepting the minutes as given, please raise your hands. Okay, minutes carry. Before we get to the update for Inspector General, just adding two things to the agenda. First, last month we did have nominations for chair and vice chair. For election purposes, would anyone like to motion for chair nomination to become the chair for the board? Thank you, Pastor Nathan. May I have a second, please?
Second.
All in favor, please raise your hands. Any abstentions? I'm abstaining. Stephanie, for the minutes. Thank you. Motion carries. Now for nominations or the election for vice chair, I'd like to nominate Board Member Jackson for vice chair. May I have a second?
Second.
Okay, all in favor, please raise your hands. We have an abstention from Board Member Jackson, Stephanie. All right, another year. Next up, I would just like to note that we do have 4 folks who are in the process of being added to our board, and that's in addition to our newest members. So Adam Rusnak, Sheldon Goodrum, Jay Bigley, and Sheila Turner. Mr. Rusnak and Mr. Bigley are here observing today's meeting. Mr. Tobias, do you know approximately when it is possible that our new members would be seated so that our off-rotating members know when that will be?
Right, so I believe an email came across from Stephanie the other day that said that the appointments are on the agenda for the May 11th city council meeting, so the appointment should go through as of next Monday.
Perfect.
I, in response to Stephanie, said, have them start their training now, please, so that they will be finished with all of that and ready to be seated for the June meeting.
Perfect. Thank you so much. With that, that means that we have our rotating off-board members who, provided everything goes to plan, this would be your last meeting. I know we do have a plan to publicly recognize Board Members Nathan, Board Member Strickland, Board Member Younger for their service. So keep an eye out for all the details for that. Yes, Mr. Tobias.
One additional thing, for purposes of case review, we cannot share the cases with them until they're appointed. So if that goes through on Monday, the 11th, I would ask that on Tuesday, the 12th, that those, I don't know if you're going to do, assign them to committees so that they'll have adequate time to review the cases before the June meeting.
Perfect. Thank you. All right, now I'll turn it over to the Inspector General for an update.
I'll say good afternoon, board members. So a couple of things I'm going to start off with. I want to talk about, and I understand that we do have someone here that's going to be presenting some training, so I'm going to be brief. There are some information that's already been sent out to the board, so if you have any questions or any feedback, please feel free to either email me or after the board meeting or in between the breaks, if you have some questions, please feel free. So going with the monthly report, I just want to highlight some things that I always do, and that is just for the month of March, we have received a total of 129 complaints were received, and out of those 129 complaints, we closed 105. We opened 24 investigations. Out of the intake of those 20 investigations that were open, we will be investigating a 105 complaints, allegations is what we'll be looking into. Nope, take that back, I'm sorry. We closed 105, and so on page 3, it gives you a breakdown of all of the different complaints that we closed and the reason why we closed those, if you want to look at that. And then going over to page 4, if you look at the fact that we opened 20 investigations, out of those 20 investigations that we opened, we also, for the month of March, we closed 20 complaints. And out of those 20 complaints that we closed, we looked at 58 allegations. Going over to page 5, we did a breakdown of the allegations that were investigated per precinct. So you'll be able to look and see how many cases were investigated per precinct. We also have the number of allegations that were investigated and the cases that were closed. We also broke that down by the number of whether they were sustained, exonerated, or unfounded, and if any were withdrawal. And out of that, again, it tells you there were 20 cases that we investigated and closed, and out of that, we looked at 58 allegations. Also, if you look again on the second page 6, we did it by year to month. So if you want to see on page 6, it talks about how many cases thus far for the year of 2026 that we have investigated, which have been 60 cases. And out of those 60 cases, we have investigated 204 allegations. And we've done a breakdown of what those allegations in turn. In the back of the monthly, for March, we always do a summary. We know that the board breaks the investigations up, so you have individual committees that are looking at the individual complaints, but what we did is we try to give you a breakdown so everyone has the ability to see what the allegations were, what the recommendations were. Some recommendations have, because it's the beginning of March, some of those have went to the board and the board has already done their findings. So again, those findings are on there. If you don't see a finding for the board, that's because it's still waiting for the finding. It takes, I want to say on average, we're probably looking at anywhere from 4 to 6 months to get a feedback from CPD regarding what their allegations, whether they confer or not. So that's why generally on the monthlies, you're not going to see that because it still takes time for it to go through the process. But I do believe that when we get those findings back, those are shared with the, I know they're shared with the chair because her and I have talked about that. So if any of the board members want to see what those findings are, I'm sure that we can make sure that we're pushing those out so you get to see what CPD's findings are on all of that. And then we report all of that towards the end of the year when we do the yearly. We add all of those findings in there so you're able to see. Are there any questions so far on the monthly? Thank you. I was going to get into the peer review, but what I'm going to do is I'm going to pivot and go into the dashboard. So the follow-up with the dashboard, we are moving right along, which is really great. We're meeting with the Do It team biweekly. There was a meeting done at 11 o'clock today, so had a chance to kind of see where we are. So they're in the process of testing how some of the data is accumulated and doing a comparison to how we actually report out. So we're just still trying to work that out. That looks really good. It looks like we, in June, might have what we call beta testing. So we might actually look at some of the designs. That's what they're doing now, is looking at some of the designs, the math, how that information is looking, how that's going to be displayed. So June might be our month where we do the beta testing. And they're kind of confirming that maybe by July might be when we're actually able to go live. So that's what we're looking at. I will definitely keep you up to date and abreast of where we're going, but I feel like we're at least moving forward, looking at the data, seeing how it looks, and how that's going to be displayed on the city's website. So, have some questions?
Of course, I'm going to have to speak because you said dashboard. So just want to commend the entire team with the Department Inspector General and with the folks at the city, the Department of Technology for doing this, and the board members. The dashboard has been a big point of, I think, conversation in terms of what we could do to have real-time transparency, what this could look like. I think this is going to be helpful for everybody. So big shout out to you all. Appreciate it. Anything that we can do to help get this to the finish line, let us know. Thank you.
Thank you, and I'll definitely keep that in mind right now. I know the city is assisting by giving us their IT people to help put all of this together, because my team we're not that tech savvy, but we are looking to see where that's gonna go once we're able to start putting that out there, if we might need to look at hiring someone to bring them in to actually manage that. But right now, IT is helping us facilitate that, and we definitely appreciate it, so. And moving right on to the peer review. So last year in 2025, the IG had asked for the Association of Inspector General, which is a national recognized organization, to come in and do a peer review of our office. And that occurred, that occurred in the month of April. Part of the peer review process is they come in and they do an evaluation of the office. They look at the policies and procedures that have been established by the Association of Inspector General, which is standards by all Inspector Generals, how they should be operating, especially in the investigation part. They also ask for information ahead of time. They not only look at the policies and standards for the Association of Inspector General, but they also look at the policies and procedures in-house that we're stating that we have established by which we do our investigations. So again, that's city policy, contracts, contractual policy. So they came in, which I'm excited to say, when they came in and did the peer review. Another thing that they do, and I'm going to just read this assessment, it says a review assessment. They review the assessment of investigative work product, staff qualifications, training, policy adherence, supervisory oversight, quality control, reporting methods, and the department's external relationships. That would be that they also conducted an interview with one of our board members, the city attorney's office, the mayor's office, city council, and the Columbus Division of Police. What we did is we provided them a list of the people that we regularly have interaction with. And so the board, again, we leave it out to the team to reach out to make a determination as to who they want to interview regarding those processes. And so with all of that saying, I'm excited to say that on the letter, and I did share it with that, is that we did very well. Their letter's basically reading what they said. It says, on behalf of the team, I am pleased to advise that we found no reportable instances of failure to meet these standards. There are no limitations or qualifications on our opinion. It is unanimously concluded that the team, that the Columbus DIG met all relevant AIG standards for the period under review. And what they did is they sampled our work and reports for fiscal year 2024 and 2025. The two people that conducted the peer review was Amy Young. She is Deputy Chief Inspector of the Executive Office of the Government of Florida, Office of Inspector General, and her partner was Keith Parks, Inspector General with the Florida Department of Children and Family Services, Office of Inspector General. They were the two that came in and did the peer review. The letter that was sent out is the opinion letter. It's a standard letter that basically says whether or not we were in compliance or we met the standards for doing evaluation. There will be another letter that they'll send out to us, which we should get in 60 days. That letter will be what they consider recommendations and considerations. So they look at how other offices of Inspector Generals are operating across the country, and they will look at our policies and procedures, and they provide recommendations for us. And so once we get that letter, I will definitely be sharing with you some of their recommendations. We are aware of some of those recommendations, and we'll probably be working on implementing those right now. But I'm excited to say, you know, that we had the peer review and the fact that we did very well. I think that says, when I see this letter and what we did, when I say it's a win-win for all of us, it's a win-win for all of us. It's not just a win-win for the department, because obviously, you know, our goal is to make sure when we're conducting investigations that they're thorough, they're impartial, and that we're providing the board with all of the information that is necessary for you all to make the recommendations and findings that you need to do, but it's also a win-win for the citizens. So I always say it because I'm sure citizens look at what we do and they say, hey, you are an oversight board. You have oversight over police. Who has oversight over you? Who makes sure that you're staying in compliance with your own policies and procedures? So now this is something that we get to say, yes. We had an independent agency that came in and say, yes. They've looked at our product and they say we are compliant with our own policies and procedures. That's what makes it also a win-win-win for the board and the community to be able to say, you voted to establish our office, to work in tandem with each other, and that we are exactly doing that, and we're doing a job. So thank you very much for being able to report out on that.
Yep, thank you, Inspector General. I'd like to commend you all for getting that preliminary finding, and just to let the rest of the board know, Inspector General Hendricks and I have talked about a evaluation process for her, as she's now in her 4th year as Inspector General, entering into year 5. And so if there are members, I'd like for 2 of our newer members to join myself, Vice Chair Jackson and Dr. Ford, for an ad hoc personnel committee, and we'll do, once the 60-day review comes in, or the, not review, but the 60-day recommendation letter comes in, we'll have an official formal process, very similar to what the DIG does for the other city employees who currently work for the IG's office. So if you're interested, please let Stephanie know, and then we will get some dates on the calendar. But thank you very much, Inspector General. Anyone have questions about either the letter or the peer review process? I was not questioned in regards to, but I know that there were other board members who did participate in that peer review process. So, any questions?
Yes. Oh, thank you so much. And it was a very thorough process, and they asked many questions, and they wanted our feedback and what we, how we wanted, what specifically we wanted to see from further from the Inspector General as we move forward. And so I provided that. And I was reading the letter that was forwarded to us. I was pleased with that, and just from the questions and from his responses and everything, I thought it was a great idea that the Inspector General asked for this review so that they could get feedback and from everyone. And they not only interviewed the board members, but I saw that they interviewed members of the police department, and you can help me out here. I think also your whole staff, and who else?
Yeah, part of the process, what they did is they interviewed the entire staff. Yeah. And the interviews are all done anonymously, meaning that the feedback that we get back is not for anyone specific. They interview everybody and they provide us feedback. They interviewed the staff. We gave them a list of our board members, so they had the chance to pick whatever board members they wanted to. They just let us know before they got here who they wanted to interview. They interviewed the chief of staff for the mayor. They also interviewed a couple of people, I believe, with CPD, Internal Affairs. Again, we gave them a list of all of the stakeholders that we work with, that we interact with, and I believe that was the other person who was, let me look at the letter. I think I talked about, oh, and from the mayor's city council, let me go back, give me a second, okay. So we talked about the board, city attorney's office. They interviewed, Tiara was our city council representative at that time, so they interviewed her. Told you about the mayor's office. City council, they interviewed, I believe that was Councilman Ramey, because that's our council person that we deal with. And then when it came to CPD, that was, I think they interviewed 2 people with the Internal Affairs Office. Again, they just picked and choose, and based on that was how they came back, just to see how that product works. So.
And they wanted to know all the specifics, how we did our cases, how they came to us, and how we relayed questions, and how viewing body camera, and just, so it was pretty thorough.
right, now we will turn it over to Attorney Jeff Furby for an update on Fourth Amendment.
Yeah, good afternoon, everybody. I'm Jeff Furby. I'm legal advisor for the Columbus Division of Police. I've been in that role now for 22 years, so I've been here a long time. It's kind of a weird job. I'm housed at police headquarters, but I'm not of the police. So I'm in their building, and I've given them legal advice for 22 years, but I'm not a police officer. So a little bit about who I am and how I do my job, so you kind of understand. I've been in this job 22 years. I was a civil litigator before that, where I represented city employees in lawsuits, mostly police officers. I have some private practice for a time where I did the same kind of work. And before that, I was a prosecuting attorney. So that's who I am. My job, I function as in-house counsel with the Division of Police. I'm on call 24/7. The vast majority of what I do is arrest, search, and seizure. Most of the questions I get are about arrest, search, and seizure, mostly from patrol officers and detectives. I have walk-ins in my office. I have calls, texts, all manner of contacts with officers all the time. Like I said, we do mostly arrest, search, and seizure. We get all other manner of in-house questions, public records, Marcy's Law, contracts. But the heart of my job is answering questions about arrest, search, and seizure for officers, the stuff you guys look at. That's mostly what I do. My phone rings all hours of the day. I get called at 5 o'clock this morning. I think officers are always trying to make sure they're doing the right thing and that they can act the way they want to. A huge part of what I do related to that is training. I do all of Columbus Police legal recruit training. I see the recruits for about 60 hours or so where we do arrest, search, and seizure training. Arrest, search, and seizure, civil liability, and some other things. I then do in-service with every veteran officer every year. I spend 3 hours in person with every officer every year. It's an amazing process, to be perfectly honest. I talk to them for 3 hours about legal trends, legal basics, new cases, new statutes. We have a robust exchange, as you would expect with police officers. I thought about coming in and talking to you like I talk to officers at training, but I don't think I can curse that much here. So I won't. No. All joking aside, it's a good process, and it takes about 50 to 60 classes to see officers on all shifts. So usually it's a class of 50 to 100 officers, and this has been a yearly thing for 20 years. So I have a pretty good sense where officers are legally, and I think they have a pretty decent sense of what we're saying to them about how to interact with the public. So with that training, the vast majority of what I focus on, we have to cover a lot of issues because there's always new cases, new laws. But what we try to focus is in what I call street level policing. Patrol officers interacting with the public at street level. That's where most of our action is, to be honest. That's where our complaints come from. That's where arrests happen. That's where evidence gets discovered. That's where most of our things come from. Detectives move slower. They get to the scene after the fact. Okay, it doesn't mean they don't have stresses they ask about, but largely I focus on patrol because if our patrol officers are doing things legally right, that solves a lot of problems for us. When the detective gets there an hour later, if patrol's done a good job, things flow naturally from there. That's where our focus is. Terry stops, meaning stops at street level, traffic stops, arrest, home entries, those kinds of things where the public is impacted the most and it impacts our cases, our people's rights, liability in the most ways. That's what we focus on mostly. We have a lot of other stuff, but that's what we focus on. A couple of things, and this isn't meant as a criticism of this board, but just talking about groups like this. I teach the law as it is to officers. Okay, the law is not always what you want it to be. So when we talk to officers, we talk about the law as it is in the revised code, Columbus City Code, the federal code, and how our courts look at it. How the Ohio Supreme Court, the U.S. Supreme Court interprets the law, interprets the Fourth Amendment. That's what we teach officers. We set the legal parameters for them. What they do within those parameters is their business. Right? So, for example, and I say sometimes with boards like this, you have to focus on that. What's the law versus what do we like the law to be? But we've had a very conservative Supreme Court for a long time. They've given pretty wide latitude to law enforcement officers to take action at street level. Okay? So that's the way we teach. Now, can police departments, can they narrow those lanes? They can. That's not my job. My job is to give legal advice and to tell them what the courts have said they can do within the Fourth Amendment largely. So that's how I come at this. We talk about the parameters with officers, the lines they have to be within. Right? What they do within those lines is their business. Let me give you an example. Several years ago, we had a controversy here, and it was one of the prior, and maybe the mayor's commission, I don't remember which one it was, but a group that was looking at policing. We had a controversy where a guy was stopped and detained for an open container violation. Which is a minor misdemeanor, so it's not an arrestable offense, but the officer stopped and detained him to write him a ticket for a minor misdemeanor. A person being detained for a minor misdemeanor has to produce ID to the officer, okay, or give him his name and information. This person refused to give ID, so he got arrested, which led to a use of force. And a lot of people on the board said, well, why would the officer mess with somebody for an open container? Why would they arrest him for an open container violation? That seems like a waste of time. You know, it led to a use of force. That seems really bad. And our answer was, they can stop a person for an open container, they can cite them, and that person has to produce identifying information or they can be arrested. That's the law in Ohio. Okay? And if we don't think that should be the law, change the law then. Don't blame the officer for following the law as it's been written by the Ohio legislature. So just kind of that's how I look at things. What's the law? What are the parameters? Politicians decide the law. Courts decide the law, or the people that run the division of police can decide to nail the lines more than they have to be. That's not what I do. So just so you understand, and you can ask me any questions you want. I brought a PowerPoint to show you, but we can talk as much as you want. So that's where I come from. That's how we do training. And so what I did was, I'm only with you for a short time today. And like I said, I can't do a half an hour of arrest, search, and seizure with you that I spend 100 hours on with officers, and that would make a ton of sense. I know some of you have this background, some don't. So I took snippets for this just to show you. I just got done with in-service last month with officers. I had 3 months of, in-service, it's a bear, but we know it's so valuable. I was with officers 4 days a week for 3 months, basically from noon to 3 every day, talking through this and taking questions and trying to get a feel for where they were. So I just pulled out a few of the slides. This is a small percentage. But when we talk about policing, we always focus on street level policing first with officers. We talk about street level encounters. Really what we're talking about, what is the appropriate legal way for an officer to interact with citizens street level? How you interact? How you do interact in a way to find criminals, to solve crime, but avoid violating people's rights. That's a big discussion we have because officers are obviously out there engaging in enforcement action. When officers interact at street level, we're always putting that interaction in one of 3 buckets. So if we have a situation, we look at what was that situation? What was that officer doing with that citizen? And it's going to either be a consensual encounter, a Terry stop, or an arrest. It's one of those buckets always. And once you jam it in that bucket, then you decide what the legal rules are for that bucket and did the officer do it right. So we try to simplify this. I mean, officers aren't attorneys either. So we try to make this make sense to them how we're going to look at it legally. So we talk about this and we spend a lot of time defining this. I'll show you a couple cases, but we have a lot more cases, examples, videos we use to try to bring the point home of how to deal with people at street level within the law. So for consensual encounters, again, what do some members of the public call consensual encounters? Anybody? Harassment? Okay. Officers see it as a tool to talk to people at street level. Okay. Can I talk to someone? If I see somebody and I wonder what they're doing, can I go talk to them and just see? And the answer is yes. Supreme Court has validated consensual encounters. The person has to be free to go. For it to be a legitimate consensual encounter, a reasonable person in that person's position would have to feel free to walk away and ignore the officer, and the officer has to let him go. But it is a viable law enforcement tool. So we always talk to officers. How do you do these? How do you approach people? Did you give them orders or did you ask them to talk to you? Were you polite? What was your tone of voice? Did you accuse them of a crime? Did you do things that would make a reasonable person feel like they couldn't walk away from you? Okay. Did you block their path? Did you take their identification? All these kind of things we're always looking at, and we're trying to help officers develop legal strategies to find crime, but to stay within the Fourth Amendment. And it's a fine line with people, and we talk to officers about this a lot. We use this case this year. One example, Haskins is a case out of Toledo, where the court analyzed whether the officer had a consensual encounter or whether the officer detained the person. The argument's always the same in these cases. The officer says it was a consensual encounter, they were free to go, and the citizen says, I was detained, I wasn't free to go. Right, so that fight happens in court all the time. In this case, the officer approached the guy, okay? He approached the guy and said, hey, buddy, why don't you come on over here? Okay, the guy walked over, and the court said, well, we think that's a consensual encounter, given all of it. You know, it wasn't particularly threatening, it was one officer. However, another officer went over and then walked him to the front of a cruiser and took his backpack. The court said, well, that's not a consensual encounter. No reasonable person will feel free to go when an officer guided them and took their property from them. So it quickly became a Terry stop, became a detention. So the court then had to look and say, okay, was it a good detention? That's the bucket we're putting it in. As the court says, consensual encounters are fine as long as the person is free to walk away and decline the officer's request to speak. Okay, so we do a lot of talking about these lines between consensual encounters, Terry stops, and what you can do within those buckets. You know, we have a lot of these, approaching people sitting in cars. We tell officers, if you approach a person sitting in a car and ask to talk, that's a consensual encounter, unless you give them orders or block them in with your cruiser. So keep your distance, approach them slowly, and ask if they're willing to talk. If they say no, then you let them go. If they're willing to talk, then talk. And during consensual encounters, you can ask people a lot of questions. You can ask incriminating questions. You can ask for ID. You can ask to search them, as long as they're free to say no the whole time. Okay, so again, we talk about these lines. This is a brief. We spend a long time on this with officers because we know these are areas where officers do find crime. We also know it's a fertile area for constitutional violations too. So we're always working those lines.
Jeff, just a point of reference, the board actually had a case that was very similar to that fact pattern where an officer walked up to somebody sitting in a vehicle and I believe smelled marijuana upon approaching the vehicle, and the board kind of had some in-depth discussions about that.
Yeah, there's a lot of fine lines there. You know, when is it a consensual encounter at the outset? Does it stay a consensual encounter depending how the officer talks to him, what they do, how close they get to him? So we're always talking about this with officers. And we'll tell officers, when in doubt, if the person's showing opposition to you, they make it clear they don't want to talk, they try to walk away, you should ask them, are you willing to stay and talk? If they say no or they keep moving, you let them go. Because they got to be free to walk away, so you don't follow them and try to badger them into a talk. I think officers get that. Easier said than done always at street level. And so we're constantly on this reminding. So Terry stops, detentions, obviously a huge part of policing. Terry's become maybe the most important case in policing in the last 50 years in many ways, right? So we're always talking to officers. Do you have reasonable suspicion that person's been involved in crime? Can you articulate why you have reasonable suspicion? It's got to be more than a guess, a hunch, a gut feeling. Can you latch onto some facts that indicates that person's committed a crime? Not that they look funny or they look weird or they look suspicious. It's got to be some factual basis. And we also talk to officers how to handle people during Terry stops. Did you handle them in a reasonable manner? Was the Terry stop a reasonable length of time? They're supposed to be short. And was it in a reasonable manner? Meaning that you handle them in a way commensurate with how they're acting and why you're stopping them. There's a big difference between stopping somebody on a gun run and stopping somebody for disorderly conduct. They ought to be handled differently. So we talk to officers about evaluating those situations contextually. And patting people down, touching people obviously is a big step. Did you have reasonable suspicion they're armed and dangerous before you patted them down? Did you conduct the pat down in a reasonable manner? We spend a long time on these things with officers. We cover cases. The Haskins case I mentioned before is a really good case, and we spent a long time talking to officers about this because this is a case where the officer said it was a consensual encounter. And the court said, no, it wasn't. When you took his backpack and walked him to the cruiser, he wasn't free to go. And then the officer said, well, I had reasonable suspicion. And so the court had to look at that. Okay, well, did you? Here, this guy had allegedly robbed a Circle K. The caller at the scene described a black male, medium-sized, wearing blue pants with white stripes on the side and a white hoodie, okay? The officers see a guy 20 minutes later, about a mile away from the scene, walking down the street. He is not wearing any of the clothes. Okay, so literally medium-sized black male, 20 minutes away, and now, 20 minutes later, a mile away. Is that reasonable suspicion he was involved in that Circle K robbery? No. And the court said absolutely not. That's not nearly enough. The officer said, well, he's pretty close to the scene pretty soon after. And the court said, that wasn't that close to the scene or that soon after. No. which you contrast, this is a CPD case from a couple years ago, in Ray AMJ. Here, an officer is on a run, I think it's just some kind of a run. He's on the porch of a house, and he hears about 20 shots fired very close by. And there's a shot spotter alert directing him to exactly where the shots were fired. He jumps in his cruiser, drives toward the location. He gets the location within about 40 seconds or so. Okay? He sees two guys riding bikes away from the location. It's late at night, and the officer says, I can scan the area. These are the only two people even close by. And they were where you'd expect them to be based on time and distance and the speed they were riding their bikes if they had ridden their bikes away from the shooting location. So the officer stops them at gunpoint and pats them down. Then they're juveniles, and they do in fact have guns on them or involved in the shooting incident. They moved to suppress and said, that's a bad stop. You had no description of us. The court came back and said, based on time, distance, proximity, we think it's a good stop. Right? So, so the time, distance, proximity, we talked to officers, if you're going to stop someone because of proximity to a shooting incident, they're going to have to be really close to the scene. It's going to have to be right afterwards, and you're going to have to be able to say they're kind of where they should be if they were leaving the scene at that speed. It's not as simple as they were nearby. So again, we spend a lot of time on these. We try to focus on CPD cases whenever we can because they're good teaching tools. Plus, we have body camera videos associated with them we can look at, and we use those when we can. Say First in Jais, another CPD case, officer stops a guy for jaywalking. Typically, officers cannot pat somebody down for jaywalking because there's no reason to think a person's armed or dangerous because they jaywalk. This guy tries to run from the officers. He's got a ski mask on in the middle of August, and he grabs into his waistband and turns away from the officer when he's grabbed. So officer pats him down, finds a gun with a Glock switch. He moves to suppress and says, well, you can't pat me down for a jaywalking. And the court says, yeah, but you can be patted down for all that other stuff that happened during the jaywalking. Exactly an opposite result here. Officer stopped the guy for an open container and patted him down simply for the open container and found a gun. The court said, you can't do that. So the gun got suppressed. So we spend a lot of time talking about all these variables of street-level policing, because like I said, we know that happens. Hodge versus Grand Rapids, a new federal case. This is an 11-year-old girl that got stopped by the police. A woman they were looking for a middle-aged white woman with blonde hair who had engaged in a violent incident. Someone says she ran to that house down the street. They go to the house, order people out of the home, and an 11-year-old girl walks out, and the officers detain her at gunpoint in handcuffs on the ground. It's out of Grand Rapids, Michigan, not here. And the court says that's completely unreasonable. Even if ordering her out of the house was okay, putting an 11-year-old girl on the ground at gunpoint in cuffs was a completely unreasonable detention and use of force. In fact, it's so unreasonable, it's a de facto arrest. So they found the officers liable here. So again, we talk about this, trying to get the limits for how you treat people at street level, good and bad. Traffic stops, we talk about all the time with officers, understanding traffic stops. When can you stop people? What can you stop them for? When can you look in their car? When can you search their car? When can you order them out of the car? One thing we try to talk to officers about, and I'm sure you've seen this here, is a lot of citizens don't understand how officers are handling them during a traffic stop. So I spent a lot of time this year, because we'd had a couple incidents we had looked at, talking to officers about educating citizens. Can an officer order a person out of a car during a traffic stop just because they want to? The answer is yes. Under Pennsylvania versus Mims and other case law, if you get stopped for a stop sign violation, that officer can say, step out of the car for me. They don't have to have another reason to do that. Average citizens don't know that. So a lot of average citizens will get upset, like, why are you telling me to get out of the car? What's going on? So we talk to officers. Before you get upset and see that as a failure to comply, explain to them what you're doing. Okay, a lot of times this is just education out there. Hey, I need you to get out of the car. I'm allowed to have you get out of the car. I just want to talk to you outside of the car. Make sure they understand what you're doing, because a lot of times there's just misunderstandings. Officers will ask people to produce a license, and every once in a while somebody will say, I don't have to do that. They do, but they don't know that. So we've tried to talk to officers about trying to educate people before we have friction, before we end up with an arrestable offense. So we talk a lot about traffic stops. So it's just basic stuff. When can officers stop people for in a car? If it's a traffic violation or equipment violation, or if they have reasonable suspicion somebody in that car committed a crime. Either way, how long should traffic stops be? Long enough to write the ticket and run the checks. That's it. unless you develop reasonable suspicion of another crime during the stop. Okay. We spend a lot of time on length of traffic stops. That's a hot topic in our courts right now, because the courts are always aware that officers are looking for things, but they don't want traffic stops turned into fishing expeditions. If you get stopped for speeding, you should have the checks run and get your ticket pretty quickly. Now, officers sometimes get curious and want to ask a lot of questions, which we talk to officers about. I tease officers, they're a curious bunch, which is good, but there's limits on that with the courts. Dunlap, just for some examples, we try to cover specifics with traffic stops that we know are problematic, we know are friction. Dunlap, officers are running plates. Some citizens wonder why officers run plates. Officers run plates all the time. They're allowed to, right? If you run the plates on a vehicle and it comes back, the registered owner has a warrant for their arrest, can you stop the car? And the answer is yes. Okay. What if, as you're walking up to the car, and this happens fairly frequently, you run the plates and it says the wanted person is a female white. You walk up to the car, it's a black male driving the car. Clearly not the wanted person. Okay. Can you ask them for their license and still keep them at the scene to make sure they're a valid driver? Our Supreme Court says yes in Dunlap. Says you can. Once you start a traffic stop lawfully, you get to finish it by verifying it's a valid driver driving the car. This is a change in the last couple of years. Window tint. Okay? Window tint has become so prevalent, and it makes officers nervous. Okay? So a question becomes, if you stop a vehicle as an officer and you can't see how many people are in the car or what they're doing, can you order the motorist to put all the windows down during the stop so you can see what's going on in the car? This court says yes. Okay, you can have them ordered to stay down, keep them down, and whatever you see in the window at that point is plain view, and you could seize it. So again, the court says, well, you can order the people out of the car. We don't think it's much different to tell them to put the windows down if it's a true officer safety issue. So again, we cover specific things like that. A lot of stuff. We cover a lot of things with length of stops, and we also talk to officers about the kind of questions they're allowed to ask people during traffic stops. There's been probably 5 or 6 federal cases in the last year on this topic, kind of setting the lines, what questions are always part of a traffic stop and what questions are unrelated to the traffic stop that could lengthen the stop unreasonably. So we spend a lot of time on traffic stops with officers. Again, our courts say questions related to travel plans, authority to operate the vehicle, safety of the officer are the kind of questions you're always allowed to ask during a traffic stop. Questions about drug possession, though, are not. Okay, you'd have to, if you're going to ask those are questions that make the stop longer, which the court doesn't like. So we talk about strategies with that and how to handle it. Compliance during traffic stop, officers always have some level of concern during a traffic stop, and with good reason. We had an officer get shot last week, obviously, during what was essentially a routine traffic stop. Okay, so we talk about that. What's the appropriate way to handle a routine traffic stop? What do people have to do during a stop? How do you educate them to understand that? And what are the laws relative to this? So we cover those frequently with them. And again, education is a big part of it. But I'm also aware, and I say this to officers, I'll be honest, when they do training. I tell them legally the best strategies, meaning the best way to avoid violating people's rights, the best way to avoid having evidence suppressed. But at the end of the day, I'm not a police officer out there risking my life either. So we'll talk to them about balance out there to stay within the Fourth Amendment, but understanding that they have legitimate fears too, which I think you can't discount. So other things, we talk about searches of vehicles. When can you search a motor vehicle? When do you need a search warrant to search a vehicle? Rarely. What allows for a search? Where can you look in cars? Miranda issues. The average member of the public has no idea what Miranda rights mean. Okay, we hear people complain, that officer stopped me and arrested me and I never got my Miranda rights. Well, they were never interrogated, so of course they didn't. So we will hear that from people, though, because they don't understand the law, which we get. When does an officer have to Mirandize somebody during a traffic stop? Usually not unless they put them in the back of the cruiser in handcuffs or tell them they're under arrest. If they're sitting in their car, they're standing at roadside, officer's going to ask them a lot of incriminating questions without any warning, because the Supreme Court says you don't have to Mirandize people until they're in custody and being interrogated. And custody means close to arrest. So arresting, we talk a lot about probable cause. What is probable cause? When can you take people to jail? In Ohio, this is another stuff that will cause confusion. There are times there's probable cause to charge people in Ohio, but you cannot take them to jail. Okay, there's certain offenses that you have to see, that have to be on view for an officer to make an arrest. That will make members of the public frustrated sometimes. You know, for example, the manager of a business calls and says, hey, this guy's in here trespassing. We've ordered him not to be here many times. He's in here trespassing again, harassing my customers. The police get there half an hour later and the person's gone. You know, they're 3 blocks away sitting on a bench. And the business says, they were in here, I got 5 witnesses, I trespassed him, you can see a video of it. He's on a bench down the street, go arrest him. Okay, he's criminally trespassing. Well, the officer cannot arrest that person because the officer didn't view the offense. In Ohio, some offenses like trespass, an officer cannot arrest for unless it's on view. All right, so that will create confusion for people. When can or can't an officer arrest? We heard complaints about that. So we talk about those things. We talk about Miranda related to arrest. We talk about pink slips and how they work. I don't know if you guys see any complaints out of pink slips or not. I would think occasionally, because it's a tough area. It's a half a step off from regular policing, because it's not really an arrest. Right? So probable cause, we spend a lot of time on what PC is, trying to simplify it. If you look at the legal definitions of probable cause, they're painful. You know, so we talk to officers about the fact, is it more likely than not, based on the facts you have, that person violated the code section? Can you match up the facts you have with the elements of a given law, basically? That's how we try to talk to officers about it. Let me know when I'm going too long. We talk about specific things. We know our problem areas. I know what I get questions about. I get a lot of questions about domestic violence, protections orders, custody. It's a tough area for officers responding to volatile incidents. How many domestic violence runs does CPD have a year? Anybody know? An incredible amount. 25, 30,000, okay? So we know officers deal with domestic violence constantly. We know they're volatile. We know they're complicated. We know the law around them are difficult. So we spend a lot of time when we talk about arrest, talking about domestic violence and protection orders. Plus, we have a lot of homicides out of domestic violence. So we spend a lot of time on this with officers. In Ohio, the bar for probable cause for domestic violence is relatively low, and there's a preferred course of action of arrest in Ohio, meaning if an officer has probable cause for a DV or protection order, they're going to make an arrest. That person's going to jail, and they're going to stay in jail until they're arraigned. So there's a lot of pressure on officers to make those arrests. And I'll be honest, I put pressure on officers to make those arrests. I'm like, if you got PC, that person should be going to jail. That's it. So that can be an area, though, where there are issues, because the dismissal rate on DVs is fairly high because a lot of victims of domestic violence do not cooperate. So it's a very difficult area for officers to navigate. I get a lot of calls about DVs all hours of the day. And one thing we'll stress to officers is, again, for domestic violence, visible cuts and bruises are not required. You can develop probable cause without injury. Okay? A victim's testimony alone can develop probable cause. So if a victim makes a statement which you have no reason to disbelieve, that by itself could give you probable cause to make an arrest, which you're supposed to make usually. So just if you look at why officers do what they do, sometimes I feel bad. I see officers getting questioned like, why did you do what you do? I'm in my office going, I told them to do that. Okay? You know, I pressured them to do that because we know the upsides and downsides of these. Protection orders. Protection orders are very difficult. People get protection orders against each other, and the respondent, meaning the person who orders against, they start pushing the envelope pretty frequently with those orders. Okay? So the police will get called into what seem like, you know, fairly minor violations, but a violation is a violation. That means there's probable cause to arrest, and the preferred course of action in Ohio is an arrest on those. So, for example, if someone gets a protection order against their ex-boyfriend, and he decides to comment on their TikTok or Facebook, or he decides to like something, that's a violation, okay? Or if he runs with them in the grocery store, okay? He's supposed to leave right then. If he hangs around the grocery store and walks around by them for a while, he's in violation. So, officers are going to make those arrests, and we tell them to make those arrests. Arrest warrant execution, going in houses, always a controversial thing. Officers can execute an arrest warrant on any offense that's arrestable, any misdemeanor or felony, if they have reason to believe the person's within the house and that's their residence. They can knock, announce, and go in the house and get them if the person won't come out and surrender. That's throughout the case law. Miranda issues, like I said, huge misunderstandings with Miranda amongst the public. Officers only have to Mirandize people once they're in custody and they're being interrogated. Most people that get arrested do not get Mirandized. Why? Because most people incriminate themselves before they're in custody. The officer shows up, like on a domestic violence run. The officer shows up in the front yard, The victim comes out and says, hey, my husband hit me in the face twice, and they've got visible injuries consistent with being struck. Male half comes out and says, I didn't do nothing. That officer's got probable cause to make that arrest right then. Or the male half comes out and says, yeah, so what? The officer's got probable cause. There's no need for an interrogation at that point, so there's not going to be Miranda warnings typically. So again, I think a lot of people in the public will think that officer did their job wrong because they didn't read me my rights. They're only going to read them their rights if they have them in custody and interrogate them. Most people incriminate themselves prior to custody, right? US v. Daniels, this was a CPD case. This guy robbed a T-Mobile store, a really violent robbery up on High Street. He hit and maced the employees at the store. He fled. One of the employees had the presence of mind to shove a bait phone into his bag as he left. So CPD tracked him down, found him. They bring him into headquarters to interrogate him, and he indicates he's taken cocaine. So the officer's like, can we interrogate this guy? He's on cocaine. Answer's yes. He walked in okay. He knew where he was. He answered biographical questions, and the court said, yeah, he might have been under the influence of cocaine, but he was able to knowingly, voluntarily waive his rights. So he was interrogated and admitted to the crime. Okay. Pink slips, mental health seizures. Bottom line is an officer has the probable cause to believe the person's a danger to self or others. You know, I'm simplifying. And they may pink slip them, and officers may use reasonable force to take them into custody for a pink slip. It's not a true arrest, but it's similar to an arrest when they pink slip somebody. We spend a lot of time talking about mental health seizures because they're really difficult, they're really volatile, and a pretty high percentage of people who get pink slipped are released fairly quickly. So we try to talk to officers about how to handle those. You know, when do they have to pink slip them versus them being voluntary? How do they handle those? What's a reasonable amount of force? We spend a lot of time, you know, I do CIT training with officers. We do this in recruit training. We do it in service. We spend a lot of time talking about use of force with the mentally ill because our court takes a very different look at that because obviously a lot of mentally ill people aren't criminals or mentally ill. So we talk to officers about the different way the courts look at handling people with mental illness, or as the courts call them, people with diminished capacity, which is an unfortunate label, but that's how our courts talk about it. Home entries, finally, we spend a lot of time on home entries. Nobody likes having their house entered. The Fourth Amendment protects homes like nothing else. We spend a ton of time on home entries. Going back, we do legal updates on everything. I'll show you in a second. We do about every 2 to 3 years, we do a comprehensive guide to home entries for all officers, kind of going through every different reason you can go in a house and how it works, because the home entries are a big deal, okay, for many reasons. You know, we talk about what is a home entry, you know, crossing the threshold, what is curtilage of a house, you know, what is an exigent circumstance, what is really good consent, you know, what is a hot pursuit. You know, we try to go through that. We talk about guns in houses. Obviously, guns are dangerous, but when is that an exigent circumstance? When can officers enter a home for or with children's services? You know, can be a difficult issue. You know, hotels, motels. I've had a rash of calls the last year about, you know, sober houses and those kind of facilities. You know, officers will call, hey, what are these places exactly? You know, do people have an expectation of privacy in their room in a sober house? Do people have an expectation of privacy in their stall or their bed in a dorm-like setting in a place like that? Because officers will come in and think, what do I do with this? I don't want to violate their rights, but I'm not sure what I'm supposed to do. I get a lot of those kind of calls. You know, the people that run the sober house want this guy thrown out. Okay, can I do that? You know, and they want me to take his bag. Can I do that? So we have a lot of those conversations where officers, I think, are trying to figure out where those lines are based on these different kinds of settings. You know, we talk about crime scenes, homes, search warrant execution, arrest warrant execution, those kind of things. We talk about searches within homes a lot, okay? Home entries, you know, we'll tell them, look, the minute you cross the threshold of a house, you've entered the home, you got to have Fourth Amendment justification. It doesn't matter if the door's standing open. Once you cross that threshold, you're going to have to justify that entry in the Fourth Amendment. Same for the curtilage. Once you enter the curtilage of the home, you got to have justification. What's the curtilage? Those areas around the home made private by the homeowner, you know, privacy fences, fenced-in backyards, screened-in back porches, screened-in side porches, hedged-in areas, areas where you would expect the police shouldn't come without justification. Those kind, we talk about that a lot. Where are those lines? I get asked about curtilage a lot by officers, like, hey, we've got a call. We're trying to figure out where we can go here. You know, apartment complexes. What is curtilage in a big urban apartment complex? Where can you go? And there's a lot of nuances to that. So curtilage, private areas around the house, proximity to the home, right? What is a consensual home entry? It's got to be freely, voluntarily given, no coercion, no intimidation at the door, and you got to get express consent. We've warned officers failing to object is not consent, okay? You need to get a yes or an okay, right? Brand new federal case, we use this is out of Newark, Ohio, a federal case. Okay? Here, officers are on domestic violence, and I'll ask you what you think. This is a good one because we ask officers for this, and they're all over the place too. Officers get dispatched on a domestic violence. Female half has been thrown out of the apartment by the male half. He physically tosses her out. She has visible injuries, and the police tell her, we're going to file domestic violence charges. She said, will you come back in the apartment with me now? I want to get my stuff, and I'm afraid to go in without the police. He's inside. They go walking up toward the front door, and he says, don't come in my apartment. She says, please come in my apartment. Can the police go in? Is that a good home entry? What do you think? What do you think? Is that consent? Is that an exigent circumstance? What should they do there? And our federal court looks at it. Our court says, basically, we don't think the officers should. The officers did go in. Okay. The court said, we don't think that's good consent because he said no. And typically you have to listen. If you have two people with equal authority, you got to listen to the no. Okay, because he has Fourth Amendment rights. It's not an exigent circumstance because they could have got her closed a little bit later. And what could they, if they really wanted to go in that apartment legally, what could they have done? Got an arrest warrant. So the court said, we don't think you should have done that. But the court also said, we're going to give you qualified immunity because we've never clearly answered that question in the past, so we don't think a reasonable officer would know if that's okay or not. So basically said, we're going to give you qualified immunity on this, but going forward, understand we think that's about home entry. So they walk in, I mean, that's a very difficult situation. When I run to by officers, I'll be honest, about half the room's like, I think that's a good home entry, right? I'm like, well, what do you, and some people are like, no, it's not good consent, get an arrest warrant. So, that, that's a tough one. So we cover that in training, and it was a very thoughtful conversation. So there's always new case law. This was hard for officers. Case versus Montana is out of the U.S. Supreme Court. It's a brand new exigent circumstance case involving a suicidal male in his house with a gun. And the court was asked to tweak the exigent circumstances doctrine, and they said no. They said, we think it works as it is, we're not going to change it. So we're always updating officers on new law. It makes it difficult to be a police officer. I mean, the courts are always tweaking. Our legislature is always tweaking, okay, the law. So we're always trying to make sure officers understand where we are at any given time. Search warrants, just quickly, we cover search warrants. We cover use of force. Use of force is the type of Fourth Amendment seizure. We spend a lot of time on use of force. We use a lot of videos. We talk about non-deadly force, deadly force. We talk about, the different legal standards. U.S. Supreme Court looked at deadly force last year in Barnes versus Felix. We talked about this. This case didn't change anything for us, really. In the Sixth Circuit, we think always looked at it this way. But we made sure officers understood where we are with deadly force. We talked about some of the cases we've seen recently involving multiple volleys of gunshots, what that means. We talk about, go back, sorry, I hate this. We talk about dealing with the mentally ill and how they look at force with mentally ill people or people with diminished capacity. We cover a lot of cases with this because it's hard. We talk about, I think, non-deadly force, the kind we see, taser use, pepper spray, those things, what is reasonable, what is not, especially relative to Terry stops and traffic stops. We do a lot of First Amendment stuff because we know with First Amendment issues, one, we can violate people's First Amendment rights, sometimes inadvertently. We know that. And a lot of times a First Amendment violation can morph into a Fourth Amendment violation because an officer tells somebody to quit doing something, which is protected speech. The person says no, and then the officer arrests them. So we end up with multiple levels of violations. So we spend a lot of time on this. Again, using as many videos as we can to demonstrate what we mean. We talk about specific things. We've had a lot of protest activity for several years here, all the time, for one thing or another. So we talk to officers about what we know are things that can be problematic. People can film or photograph officers in a public place. We talk about officers about the lines with that. Okay, people can protest in the public right of way. People can call officers mean names, right? Okay, all manner of activities protected. Public events, like the Arts Festival. Can people protest on the grounds of the Arts Festival? We have that every year. We have protesters show up. They walk around the Arts Festival with signs and protests. Usually one of the vendors will be like, hey, look, this guy's in front of my booth protesting. Nobody wants to come here and shop. Can you make him leave? You know, what's the answer? We can't. It's a public street open to the public. Anyone can come to the Arts Festival. It's not closed off. They have a permit to use the street, but it doesn't close the street. So you got to endure the protesters. And the officers know that, but the officer's like, hey, this vendor's really upset. I'm like, I get it, but that's First Amendment activity. And First Amendment activity is sometimes ugly, painful. It's supposed to be a little bit. So the officers, I think, are pretty conditioned now to this. You can't make people quit protesting because they're making people mad. It's kind of the essence of First Amendment activity. People can have graphic signs during protests. We get people complaining at officers or about officers because they don't think officers do enough. For example, have you seen the signs on the walking bridge over 315 ever? Have you ever seen protesters up on that walking bridge holding signs? We get complaints about that all the time. Why don't officers make them take down those graphic signs? Right, because they can't. Right? Or we'll get some of the protest groups now, they'll set up in the public right-of-way between city schools and parking lots, so everyone has to walk past their signs going to their cars. The parents complain because their kids have to see graphic signs going to the cars. I'll get those calls because sometimes officers will kindly give out my cell phone number to people that are mad. And okay, I don't know, Furby said to do that. I'm like, so I'll get called, and the answer is they're in the public right-of-way. It's protected speech. Police can't do anything. And so officers, I think, are pretty well versed on these issues. And the line between noise violations and protected speech, we're always talking about that. Lots of complaining about loud protests. We'll tell protesters, you're allowed to say all the stuff you're saying, but it can't be so loud you're violating other people's rights. So always trying to find a balance there. Finally, we do legal updates all the time. I cut out some examples. We did one about a month ago, getting close to a month ago, on all the new marijuana laws. Marijuana laws have changed in the last month. Obviously, recreational marijuana was legalized in 2023, I believe, late 23, early 24. Well, the state legislature finally addressed that. They've been fighting about it for some time. They finally addressed it. Recreational marijuana is still obviously legal, so is medical marijuana, but they regulated it more tightly. Right? So we had to go back now and re-educate officers on all these marijuana-related issues and what is now legal or illegal. For example, it is now illegal to smoke marijuana anywhere except a residential place. So no public smoking. It's illegal to possess marijuana, recreational marijuana from another state. It has to be from Ohio. Okay, so we've had to go back and re-educate officers on all of this. Yeah, we do these updates frequently. They're always about 10 to 15 pages long. New topics, new cases, new trends, new laws. Another one we did back in December, talking about a bunch of short subjects, searching vehicles, questions you're allowed to ask during traffic stops. Here's another one from last summer. It was a Supreme Court menacing by stalking case. It talked about other vehicle stops, talked about criminal trespassing, when you can or cannot arrest. So we're always trying to update officers on this. We do these legal updates frequently. We do training and handouts for many things, detective school, coaching, all the different things that CPD does. We're trying to have a constant flow of legal information because it's really important officers know the law as it currently is. So I probably went way too long, but this is a snippet of what we do with officers. One thing I always say is that being a police officer is hard. We expect them to know a lot of stuff, right? We expect them to know a lot of stuff. That doesn't mean that they shouldn't be accountable for making mistakes. We do expect them to know a lot of things. I feel bad sometimes. We give them a ton of information, and we're constantly recycling it, pushing it out, because there's a lot for officers to know. And we encourage officers to call us. We'll say, look, if something's happening and you don't know, pick up the phone. We want to help you. It's myself and another person are the legal advisors. I'm working on another person now. My last person just left. But we're available 24/7. And I think being a police officer is very difficult because the amount of information we expect them to understand in dangerous, stressful situations. So if you have any questions, feel free. Otherwise, I'll leave. So
Yeah,
I was going to say gladly, but I don't mean it that way.
I had a question.
Sure.
Mr. Furby, thanks so much for the presentation. I just, real quickly, in restating this domestic violence arrest rule, does an officer have an affirmative duty to arrest someone if there's no visible evidence of domestic violence, but the victim, alleged victim, says, he hit me, he said, I didn't hit her?
Yeah, so the way Ohio, if you look at the statute, the way Ohio law reads is, there's multiple ways to develop probable cause, one of which is through a witness statement. Okay, if there's a witness statement submitted, it can develop probable cause. What I'll say to officers, if it's a witness statement which you have no reason to disbelieve, I mean, sometimes you get a witness statement, and you think that could not have plausibly occurred. Okay, but if it's a witness statement and you have no reason to disbelieve that witness statement,
Yes.
no objective reason, that provides probable cause to make the arrest. And under Ohio law, the preferred course of action is to make that arrest. And if you don't make that arrest, you're supposed to do a written statement as to why you didn't make the arrest, given there was probable cause. So the statute is very much worded toward, if you have PC, even minimal PC, you should be making that arrest.
Okay, then a question for the Inspector General. Do you have the capacity to search your database of cases on fact patterns, not on, we had 12 allegations of abuse, 25 on profanity, but rather on fact patterns like domestic violence? Because here's my question. I think I have recollection of a number of cases, not just one, but a number of cases which had exactly the fact pattern that I just asked Mr. Furby, that we dismissed because it was a he said, she said situation in which the officer did not arrest, and in which you said, well, the evidence was in equipoise, and therefore we couldn't prove. Yeah, so Mr. Furby, you want to say
I do
something?
want to add, though, there are times when the officer doesn't have probable cause. I mean, there are times when an officer, and I've had those calls, when an officer cannot get past 50-50. Probable cause means more likely than not. There are times, even with a witness statement, where there's, things to disbelieve or facts that are inconsistent, where you think, I can't get the probable cause.
Yeah,
So
no,
it-
these weren't,
So that-
well, then maybe sharpen it for me just a drop, because these were situations in which, the typical situation that we're reading is wife says or girlfriend says, he hit me, she says I didn't. They talk with the two people, they can't determine because there's no visible evidence.
Yeah.
What I was understanding you to say before was the law tips toward victims of domestic violence, and that, even without marks, or
Yeah.
we're going to say, look,
Yep. Let me
Yeah.
clarify one thing. The law, I don't want to say it tips, there always has to be probable cause. Okay?
I understand.
And what the law really says is if there's probable cause. And when I said a statement, a written witness statement will provide probable cause. Sometimes if you have a statement, sometimes witnesses don't want to commit that to writing. So an officer could have, hey, I'm 50-50, I don't have a written statement here.
well, do they ask for a written statement?
I think usually they do, yes. And again, I have to
I'm
be-
pressing the point because we've had a number of
No, I
cases like
understand.
this.
I just
Yeah.
want to be careful that, these are all context specific. Like I
Gotcha.
said, there are times, I'll have these conversations with officers where they cannot get past 50-50. They don't have a written statement. And that may be the officer documents why they didn't have probable cause and does one of a couple of things, takes a report and refers them to prosecution for further follow-up and intake. So it kind of depends on the facts. I don't want to imply that whenever the officer gets a statement, they have probable cause. The way the statute reads, if they get a written statement from a witness, they do. And I will tell officers too, if they get a statement from a victim they believe, they can act on it for sure. But there certainly are times when an officer does not get past that probable cause threshold because of the context. And like I said, there does not have to be visible injuries, but a lack of visible injuries, especially if a really violent assault is alleged, could lead you to think the facts are not accurate, if you know what I mean. So again.
He punched me in the mouth. Well, there would be evidence of it. But
Yeah.
the typical case that we've had in the past is, really a he said, she said kind of thing. The officer makes no arrest. The alleged victim is the complainant and says the officer refused to arrest because there was this dispute. How would you advise us to handle that?
Yeah, I think you should look at the facts, look at the statute. I mean, there are times when officers, I'm not going to say officers are always right in this situation. I'm certain there are times when officers had probable cause and did not make that arrest. And we go back, we look at those, we retrain, we talk to prosecution. Prosecution and I talk all the time. Are you seeing domestic violence referrals where an officer referred them down to intake when the officer had probable cause at the scene and likely should have made that arrest? And occasionally we do see that. We look at it and we usually do follow up with the officer. Hey, why did you not make an arrest here? So we always backtrack on those and try to figure out. Our domestic violence prosecutor is Mary Lynn Caswell, who does a great job. And Mary Lynn will apprise me when she's seeing things she finds problematic. For example, a referral where there is clearly probable cause. You know, she'll say, why was this a referral? Why was not an arrest at the scene? And usually they'll follow up with filing the charge then and make sure what happened should happen. Yes, I'm not going to say that an officer doesn't ever miss on that.
Yeah, the other thing that I would caution is I would be very concerned about the board substituting its determination of probable cause for the officer's determination of probable cause. So, you know,
I was just trying to get clarity on what the law was. That is, does the law tip, maybe it's I'm really slow and I'm really old, but I was hearing that the law tipped toward the victim, but now I'm hearing
But no, I
something
don't.
else.
If there's probable cause, that officer ought to make that arrest.
Okay, so when there's a he said, she said, and you're advising an officer,
Yep.
would you tell the officer you don't yet have probable cause?
Well, first of all, I don't tell officers to make arrests because I'm not out at the scene. Okay, I want to be clear about that. I'm not at the scene. I'll tell officers, okay, what are the facts? What facts do you have? What are the histories? You're looking at the whole picture. Okay, what are the relative sizes of the parties? Okay, do we have any witnesses? Do we have any neighbors who heard anything?
No, they're screaming, and, I mean, the typical things that we're seeing is they're screaming, they're fighting, she calls and says, he hit me, he said I didn't touch her. They take the two parties aside, she's yelling, he hit me, he's saying I didn't. That's the
Can you get the probable cause? Do you have a written statement? Can you get the probable cause? That's what I'm going to ask them. What do you have out there? Do you have a written statement? Do you have any way of getting past 50% on this? And sometimes they can't. Sometimes, like, I don't have anything here. I think the stories I'm getting are both inconsistent with what I see. I see no signs of violence at all.
And so to put I don't mean to keep hitting
No,
this,
it's
but
okay.
to put a sharper point on it, does the officer have a responsibility to ask the alleged victim are you willing to make a written statement?
I'd have to go back and look. I don't want to say a responsibility. I think so, but I'd have to go back and look at how it's written, to be honest. I think most officers will ask for a written statement in that situation. I'd have to go back and see how the directive is worded, to be honest with you. I don't want to say they have to do it because I don't remember.
Yeah, because I can just recall, I mean, we've had that case
Yes.
multiple times,
Yeah,
and
and,
we
I'll-
typically say unfounded.
I'm not going to, I'll be straightforward. One, Robert's right. It's hard for me. I don't substitute my judgment from my home in the middle of the night for the officer, what he's seeing. I will ask a bunch of questions and we'll talk about the law, but I'm not there. But I will say, we are always looking at that. I mean, I have a long conversation with prosecution all the time. Are we making those arrests there when we should? Are we missing? And Mary Lynn Caswell, like I said, is our DB prosecutor. She's been in that job a long time. Mary Lynn always tells me the same thing. CPD is the gold standard for domestic violence enforcement. They do better than anybody in the state on it. I mean, we have, our group that does the strangulation cases, but she will point a case out to me occasionally and say, I look at these facts, I think they probably should have made an arrest at the scene. That does happen, and we backtrack and look at them. And most of the time, the officers have a reasonable explanation for why they didn't, even if I don't necessarily agree with them. I mean, I was a domestic violence prosecutor 25 years ago. More than that, actually, a long time ago. I was a domestic violence prosecutor. And I very much, if there's minimal PC, I'm going to tell an officer to make an arrest. You got minimal PC, make the arrest. It's the safest route for everybody, and that's what the law says, too. Yeah, those PC decisions, I don't want to make it sound too easy. Like I said, they're not easy out at the scene. But we will walk through, officers, have you done all the things you're supposed to do to figure that out? And that's the one stress we've had in training lately is we don't get in trouble for you making tough decisions. Sometimes we get in trouble if you don't do all the things you're supposed to do to make those tough decisions.
I think what you're trying to do is make this black and white when there's literally 100 shades of gray here.
Yeah.
There's so much nuance associated with it. You know, some of the other things that Jeff may not have mentioned, you know, when an officer's at the scene is familiarity with the parties, you know, any prior criminal history, you know, prior incidents between the parties. There's probably, you know, 28 different criteria that go into that decision-making, and it's very nuanced.
I didn't know, perhaps I misheard, I didn't know if the law took a position when there are competing narratives. That's what I was attempting to.
You're looking at things like
get at.
primary physical aggressor, size of the parties. Like Robert said, have you been to the location before? Is there domestic violence? You're looking at everything to try to get to some determination. Can you figure out who is the primary physical aggressor in this situation?
Jeff, is there, I know, I was a domestic violence prosecutor as well, but it was many years ago.
A long time ago for both.
The phrasing that I always remember is preferred arrest policy, and if they're not going to arrest, they need to articulate why they're not
Right,
arresting.
right.
I don't recall us, Mr. Tobias, I just don't recall us ever articulating a preferred arrest policy or anything other than a complete.
Yeah. Preferred
sort of-
arrest, preferred arrest isn't just in policy of CPD, it's in the revised code. So and that's been in the revised code since the mid-90s or thereabouts.
Right. I don't recall us ever discussing preferred arrest as.
Yeah, and there's the specific code sections also
Yeah.
talk about the different criteria for how an officer should figure those things out.
So back to the IG, and then somebody else may want to ask a question, or we can move on. Do you have the capacity to search your database for our domestic violence cases?
I'll have to get back with you on that because the cases that we have in there, they are not cased by what the actual allegation is. So I would have to get back to see if we're able to do maybe like a word search
Yes.
where a violent case. And here's the issue, is even if we bring those cases up, we're still limited for the 90 days in which we're able to.
Oh, I'm not suggesting that we go back and revise cases from a year or two ago. I just was wondering if we could pull those cases up and even begin to get some learnings from them, like, do we have this preferred arrest language? Like, has that ever been mentioned in any of this? I don't recall, and, you know, that ever being mentioned as part of the Ohio Revised Code, and us taking a look at that. I was under the impression that, and I don't recall ever having a conversation about, you know, an officer asking for a written statement and the complainant refusing, or discussion about the totality of circumstances. What I recall, and it could be wrong, but what I recall is it was he said, she said, that's it, done. We don't have anything more. And now we're adding much more nuance, much more complexity to it, and I'm just curious as to
it is
how would we
complex.
decide based on what we're hearing now?
And so, and let me follow up too. The issue I will say is, if you're asking, first of all, if the board is asking for us to do this, what is the basis that you're asking and what are you asking us to do? Because taking the time to actually research any cases that involved a case where there was some type of domestic violence, what type of outcome is that and what exactly is the board looking to do? Because that's work that's going to be taking time for us to do that. So the thing that I would be asking, exactly what are you looking for?
I would be looking for, if I were still on the board, which I won't be after this today, what I would want, I would just want for me, I would just want a collection of those cases sent and let the board do the work, if they're interested in doing it, of reading over those cases and saying, did the IG discuss any of the factors that Mr. Tobias and Mr. Furby are mentioning? Because I don't recall us ever having this conversation. What I recall is that when it's a he said, she said, we just automatically say unfounded. And I'm saying that, what I'm hearing is, no, it's more than that.
It's a lot more than that.
And if I could, just for, so I went ahead and looked through my own notes, because I keep notes at every meeting. I do not say this is exhaustive, but here are the cases we have in which we had similar scenarios. 2024, 1434, 2023, 1545, 2023, 1490, and 2024, 0942. On one of those cases, the primary issue that we identified as needing a policy change was specific to an interpreter. So that was a case in which it was a domestic violence call, but what the board ended up making a recommendation for was the fact that the child of the person who was the complainant is who was used as an interpreter instead of actually getting a real interpreter to the scene. Second, 1490, we actually sustained, or the IG's office sustained, and the board affirmed that sustaining, where both people gave conflicting stories about what happened, and the officer's behavior was sustained as being violative of policy in that case. The second two, the other two were both withdrawn or closed, and I think that's where we had more discussion, was 1434 and 1545 were both cases in which the complainant, and by complainant I mean the person who initiated the call to law enforcement to come and respond to the DV call, ended up, likely due to fear or something I assume, ended up not cooperating following either the initial call or following up on the complaint. So in one of those, the complainant did not respond to the IG's office after multiple attempts. For the other one, it looked like by the time officers arrived, the person was saying nothing happened, even though everyone who read the report probably perceived that something had. So that's just 4. I don't know how many else there are, but if.
And I'll be curious to see what you guys saw on all of those, because I'm just thinking through, I don't see every domestic violence packet, obviously, there's a ton of them. But I don't usually see a witness statement or a victim statement in them. Usually there's a statement. And I don't know if that's apparent in them or not. I'm just thinking through the ones I see, there usually is a written statement of some sort. And there are some of these, you have to realize, when the officers get there, people do not cooperate fully.
Sure.
So, I mean, like I said, if you have probable cause in Ohio, you're supposed to make an arrest. That's the law. But getting the probable cause is difficult. They're more complex than he said, she said. You're right about that. And we spend a ton of time on training with that. Our office spends a ton of time on training. In recruit training, they get a week of domestic violence training from our people. So, it's a long discussion. CPD has a sergeant, Sergeant Carney, who does an amazing job with training. It's a constant focus of training because there's a lot of DV runs. They're very difficult. They're volatile. And they're dangerous to everybody, the victims, the officers, everybody. So, like I said, and we have talk all the time. If we think someone misses, we talk about it. So.
Mr. Furby, under this preferred
Mike?
under this preferred arrest policy, if an officer decides not to arrest, he or she looks at all the circumstances and decides, are he or she necessarily violating policy?
No, they have to document why they didn't. There may be a
Okay.
legitimate reason why they did it, but that should be documented and apparent.
All right, because our job as the Civilian Review
Looking at
Board,
policy.
Civilian Review Board and Inspector General is to determine if there's excessive use of force or a violation of policy.
Right.
So those are our focuses.
If there are certainly times where officers don't make an arrest and they articulate why. And there are legitimate reasons.
Right.
I think through over time, maybe like one of the parties was transported to the hospital and couldn't be arrested at that time. Or there are legitimate reasons why an arrest is not made at that time. Or it involves a child. We will have those where the officers will learn of the domestic violence days later through a principal at school or something. And by that point, Children's Services is involved, and the officers decide it doesn't make sense to make an arrest at this point. There's already action taking place. So those are legitimate reasons that get documented. You don't violate policy just because you didn't make an arrest. There are legitimate reasons why you didn't.
Right.
But we're looking for some articulation why that is.
So you could have a he said, she said,
Yeah.
but there are circumstances that dictate to why this particular officer did
He
this.
said, she said, victim declined to do a written statement, couldn't develop probable cause. It could be many reasons why they don't make an arrest.
Okay, thank you.
I've got,
This is about traffic stops. You know, some of our community perceive that some traffic stops initiate based on profiling. What determinations does an officer need in order to stop someone for what I would consider a minor traffic offense, like a turn signal violation?
So I'll be honest, see, our courts, the way they look at, they don't get much into motivation. Okay, if there's a turn signal violation, equipment violation, reasonable suspicion they committed a crime, it's a good traffic stop. It's just, our courts don't get into underlying motivation because it's almost impossible to do that. So if an officer says, oh, they didn't turn their turn signal on, and you can see that in the cruiser video and body camera, the court's not gonna look and say, well, why did you really stop them? The court's gonna look and say, well, there's a turn signal violation, it's a good stop. They just don't get much into underlying motivation. I'm not saying profiling's never happened, I'm just saying, if there's a violation, the courts don't go much further with the evaluation, because it's almost impossible. How do you prove an officer stops someone for profiling if the person was going 15 miles over the speed limit? And when I was a prosecutor, I remember people would walk in and say, I don't think he stopped me for speeding. And I would jokingly say, were you speeding? Yeah, but I was only 10 miles over. I'm like, what do you want me to do with that?
So at what point can they then extend that stop? We have a case that we're going to review shortly where a person conducted a traffic stop for a turn signal violation. They pulled over the vehicle. Within 2 minutes of the stop, they called for a canine unit. And in the report, they said the reason was that they were in what was quote unquote a high crime neighborhood and the person was driving a nice vehicle. So at what point can you then say that turn signal violation then turns into a canine search?
Well, it depends. It depends. So officers can bring a canine to the scene of a traffic stop for no reason at all, as long as they can get that canine out there during the reasonable length of the traffic stop, meaning during the time that officer's running, checking, writing the tickets. You don't have to have reasonable suspicion or probable cause to bring the dog to the scene. If you want to make that stop longer to wait for the dog, you need reasonable suspicion generally of drug activity. Okay? And what would be reasonable suspicion? You gotta look at the totality of the circumstances. If the only factors are high crime area, nice car, I don't think that's reasonable suspicion. I don't know all the facts.
Right.
Okay, I don't know all the facts. But we would be looking at the reason the dog was brought out there and how quickly they got the dog out there. Like I said, if they can get the dog out there in that window of time between when they make the stop and they're done writing the ticket, they can run that dog around the car without any legal basis.
And that's what they did.
Because U.S. Supreme Court has said that's not a search under, because you don't have an expectation of privacy in the odors coming out of your car during a traffic stop. If they made the stop longer, then they'd have to articulate why they reasonably suspected drug activity. So it kind of depends on how it went down.
Right, okay.
I've got a question. Thanks so much, Mr. Furby, for this really fantastic presentation. I think, I'd be curious, your insights. Obviously, this board has been up for 5 years now, and just trying to get a sense of both in terms of how CPD interacts with DIG, in terms of this board more broadly, how your office can kind of think about what the board, how we can approach some of these issues. Because there, of course, is what is a violation of policy, what is a constitutional violation of law, and then there's these questions about like what's best practice, right? And that is obviously not all of the pieces that you're doing, but this is what comes up often. Right. One of my questions that I have is, and feel free to get back to me on this as well, which is, just given what you've seen and over time in terms of with this board, with the Department of Inspector General, potential points of tension with CPD, what are potential steps or opportunities for this review board, in addition to bringing you in to provide these updates, could really do to kind of facilitate these discussions around best practice and what we should be looking for, what we should be looking at? Because the cases that, Board Member Caldwell just mentioned, you're not going to figure out on this one case, but if you're looking at whether or not there are patterns, in a particular officer, if there's been patterns over time, then you might be able to see something, if maybe or maybe not. So how do you think about repeated violations? How do you think about where we're missing, what we need to be focused on, or in your own opinion? I just would love to get your insights.
That's a long question.
Yes.
So I can get back to you on some of it. My impression is when this process started, obviously the police had their skepticism, concerns about these processes started. I don't feel that so much anymore, to be honest with you. I think with the IG, I think the relationship is pretty positive with the police. I think they all understand each other's roles now. When the processes started, of course, the police didn't love it. I mean, they were concerned what that would mean, you know, but I don't see that now. I think they see the roles and they understand them. Now, you asked me a bunch of questions about, you know, looking at repeated violations. I'd have to think about that. And I look at things, like I said, I'm a legal advisor. I think a lot of what you guys see are not legal issues sometimes, but rudeness. Rudeness is not a legal issue. I mean, I don't like rudeness. I tell officers rudeness often will impact the legal issues we have to deal with. It's hard to convince, you know, a court a use of force is reasonable when you've been rude to them first, all right? But that's not my issue. So it's not a constitutional violation, you know? So to have to think about how you look at that and how you maybe better interact with the police and get information from them, I have to think about that. I mean, that's a large question.
Yeah.
I will say, I think the overall environment's a ton better. I think, I feel like it works relatively well at this point. It's been my impression. You know, I think a lot of the concerns the police had at the outset have proven to be, you know, misguided.
Great. All right. Thank you. Appreciate it.
Any other questions for Mr. Furby? I'd like to reiterate my thank you for coming again and sharing with us. We appreciate it, and I'm sure that we will have many questions in the future that we'd ask you to come back and talk about very issue-specific
No, thank you for
things.
having me.
Very helpful, thank you.
All right, we will take a 10-minute break, after which we will come back and dispose of the rest of the agenda. So we'll see everyone back here. We'll just say at 3:45.
Oh my.
To, for sake of time, push the bylaw review, Stephanie, till our next meeting, if that's okay? All right, thank you. So we have a handful of cases from committees 1 and 2 that we need to revisit briefly, and then we'll turn to cases from April. So I'll turn it first to Committee 1.
Sure. So we had 3 cases that we sent back to the IG for further review. And case 2025-0549, 2025-1060 and 2025-1093. The DIG sustained the allegations as we recommended in 549 and in 1067. We concurred, and so I would move, let's see.
1060.
1060, okay, 1060. Oh, 1060 is waiting for the BWC. So, 1093, there we go.
Second.
So 549 and 1093, they sustained the findings as we recommended, and we agreed with their findings, so I move to accept the DIG's findings in 549 and 1093.
Second.
Okay, we've got a first and second. Any additional questions about those 2 cases?
And then regarding, I'm sorry? Oh, do we have a question?
It's okay, no questions. We'll go ahead and call the vote
Oh,
on those
excuse me,
2. All
sorry.
in favor of moving those forward, please raise your hands. Any opposed? Any abstentions? Okay, motion's carried.
And then we're still waiting on the body-worn camera evidence on 1060 because it's under investigation right now. And so then I'm assuming, Mr. Tobias, that, as we said last time, that tolls the running of the 90 days. And so we're just waiting on that.
Okay. All right, and then Committee 2 also had a case holdover from last time, I believe?
Yes, Committee 2, that case was.
Mike.
That case that was held over was case number 25-1067, and that was for the IG's additional reconsideration. And they did reconsider it, and we did re-review it, and at this time, we do concur with the finding of the Inspector General.
And Board Member Yeager, what was the finding after reconsideration?
That the DIG recommends that it be closed with a finding of unfounded.
Okay. All right, do we have a motion or
No.
question? Board
Yeah,
Member
could you
Strickland?
refresh me on which one this was, the subject of this one?
Was the complaint stemmed from a traffic crash where the focus officer was involved on his way to work.
They were using the flock system.
He improperly accessed the flock camera system.
What?
thought
He
it was
was,
Sorry, thank you, Lily. This is the flock system.
the flock.
So,
and the inspector, we wanted to
Re-review.
re-review, and they, let's see, so the focus officer's use of the flock hammer system indicated that, let's see here. The issue was that he improperly accessed that flock hammer system. And we wanted to have them reconsider it. They did, and they found that it was unfounded, and
So the reconsideration came back with the same determination?
I think they changed.
Sustained.
Yeah.
Sustained, Mayor.
Excuse me. It was
I'm
actually,
sorry, forgive me. It was sustained.
Okay, I agree with
Forgive
that.
me,
Okay,
forgive me.
thank you.
Thank
Big
you.
one, all right.
God.
There you go.
All right, may I have it?
Meeting, and I'm.
Yeah, you're one foot out
Chair,
already.
Chair Burns, I'm sorry, that's just a note, it's on the thing, you guys actually agreed and voted on it in April contingent
Conditional,
upon
yeah.
the change
Them
by the
changing, that's
DIG.
correct.
And it was signed by, it came and it was signed and sent to, it was signed and agreed
Okay,
upon
so
by
this
you
is
guys.
just an update.
It was
that
just to let you
was-
guys know.
Perfect.
Thanks.
Thank you, Stephanie.
Thank you.
All right, turning now to April cases, back to Committee 1.
So, let's see. I want to make sure I have them in order here. I have, oh, this is a 2025. Yeah, in case 25-1148, 007, well, we have, I'm going to have to break them up because the IG added allegations in case 121, but 007,
Board Member Nathan.
0015.
Just for clarification, the first case is a
is
2025. I just want to make sure you
2025, and the
reference.
others are 2026.
Okay, thank you.
Thank you. 0024, 0042, and I think that's it, is it? No, and 0045. We concurred with the Inspector General's findings in all of those cases, and so I move to accept the Inspector General's findings in those cases, and then there will be an additional motion in case 2026-0121. I'll hold up on that. That was an additional, the DIG added an allegation for failure to activate the BWC. So, so regarding all of those cases, I move to accept the IG's findings.
Second.
Okay, so we've got open motions on 25-1148, 26-0007, 26-0024, 26-0042, and 26-0045. Any discussions or questions on those cases? Seeing none, all board members who are in favor of moving those forward as given, please raise your hands. Any abstained? Any opposition? Okay, and so do you have 26 now?
And then
002?
2026-0121, this is one of the more recent cases involving a special duty officer who, according to our new board policy, we required that, we asked and the city agreed to require BWC for special duty officers. In this case, the officer did not activate his BWC, and so the DIG added another charge of failure to activate the BWC and sustained that, and we concurred.
Okay, so may I have a motion for?
Oh, so I move to accept the DIG's findings in 2026-0121. We did ask Inspector General to look at other evidence. There wasn't any. It actually took place away from the shop, so there wasn't any video because of the distance from the store. And there was no admission in it that he didn't regularly activate his body-worn camera. At least the Inspector General came back and said that in their estimation, he did not admit that.
Yeah, I think my reading that report, 121, there was an indication of he did not have it activated to preserve battery or something like that. I just wanted to get I want to make sure I'm reading that portion correctly. Pulling that up. Yeah. So it says, he said that he knows, this officer who was assigned special duty, he said that he knows the BWC policy regarding interactions with the public. He explained he does not leave his BWC on for the entire day. So that explanation to me, I mean, why is that part of the policy? I would love some further clarification there in terms of why he would not leave it on during the entire day. Is it just during the interactions? Like, we want to get a sense of that.
I think in regarding this incident, officers are required to activate their body cam footage when they have an interaction. We do know that depending on when officers are like in their vehicles and stuff like that, they don't always necessarily have their body cam on. We do know that sometimes depending on if a run or something occurs, what happens when it's activated, it'll go back so many minutes and start to capture it. So in this instance, because there was a interaction, well, based on the information, we were able to make a determination in this report. The officer was notified why he was in the store to have contact with this person. So he stepped out. I think the person was down the street, but we still said because you were having some type of verbal conversation, you should have activated, and he did not activate it. And so that was the reason why we did the sustained conduct for him.
Excellent. And then part of that, I think one of the questions we asked was, what's the, incentivizing, or like, what's this to keep from incentivizing someone not turning it on? And then you talked about progressive discipline policy if there are continued violations. So.
Right. I mean, I'm not an expert, but what I can say is if you want to have somebody come in to talk about the collective bargaining agreement, we do know that as officers are sustained, there is a progressive discipline that occurs, so how they're disciplined. So we do know that officers, if the same incident occurs over and over again, there is a progressive discipline that they get. And the reason I say progressive, because officers can be found guilty of not turning their body cam footage for one thing. They might be hit for rude and discourteous. So those are two separate incidents. So you ask, what is the incentive for them not doing it? Is as you're hit for not violation policy and procedure, they're disciplined for that. Yeah. So to me, that would be and again, we did provide to the board, I believe, when we did the yearly report, a list of officers.
That's right. Yep.
So the board has the ability to see if we continuously get the same officer or the same complaint for a progressive long time and they want to make some type of recommendation. You definitely can do that.
Excellent.
But there is a record that is kept of that. And also I can say that CPD has a committee called EARS in which they themselves monitor progressive instances that are occurring. And you could definitely have CPD come and speak a little bit more on that if the board wants to see what CPD does as far as monitoring disciplinary. Because again, their disciplinary that they look at we have our process here, but the command level also has a process in which they investigate complaints that come from the command level that are not citizen complaints. So all of that is monitored by CPD.
Excellent. Thank you. Appreciate it.
I had a quick question. Special duty officers, are they using the same Axion system that is assigned to them when they're doing regular duty service?
Yes, it's the same.
same.
So we're able to see that. That's how we were able to make a determination based on the complaint that there was no body cam footage available involving this incident.
In this particular case, that officer, I just want to make sure I'm clear on this, he mentioned that the reason why he had his camera off is because he was trying to conserve his battery, or is that the gist that I was getting in this case? Because I just know, like in my background, that you activate it, no one keeps their body camera on the entire day. I mean, it's gonna drain, so.
And I think that's what he was saying. I know that based on policy, if they have an interaction, they are supposed to hit that body cam footage. So he may have just stated that he just didn't have it on all day, but when he stepped outside,
Got it.
For the incident in which they are required by policy, when you have an interaction with someone, that you should be turning that body cam on to capture that, and that's did not occur, and that's, why we did the violation.
Just want to make sure there isn't two different cameras that they're using, one for, on duty and off duty, or special duty.
No,
Okay.
it's the same system.
Okay, thank you.
Okay, so we've got a motion for case number 26-0121, plus the additional allegation from the IG's office. Do I have a second?
Second.
Okay, any other questions or discussion about this case? Okay, hearing none, all in favor, please raise your hands. Any opposed? Any abstentions? Okay, and committee one, it looks like you still have 26-0015?
Let me see. Say that again?
0015. Does that sound right, Stephanie? Okay.
I think it was mentioned when Board Member Nathan originally mentioned all of the cases, but then when
I
the
did.
motion was made, that number was not included with them.
Okay.
Oh.
I will go ahead and then call for a motion.
Yeah,
on-
0015, we concur, we agreed with the Inspector General's finding.
Okay, I'll call the motion again for cleanness of minutes. May I have a motion on case number 26-0015?
I'll move.
May I have a second?
Second.
Okay,
Let's
all in
keep it
favor?
clean.
All in favor, please raise your hands. Okay, any opposed? Any abstentions? Motion carries. Thank you. And again, thank you both for the recitation of your your ultimate case list for us. We appreciate it. Committee 2, April cases. Mike.
As to case number 25-1132, we have case number 26-0014, 26-0022, 26-0044, 26-0075, 26-0081. Our committee met at Dr. Ford's office. We discussed these cases, and we did concur with the Inspector General on all these cases. So we move that that the board accept the finding of the Inspector General as to all 6 cases.
Do I have a second? Second. Okay. Any questions or discussion on these cases?
I just had a question about that stop that you all mentioned. Was that a point of discussion among your group? I just would like to get a sense of that determination there that was made.
Yeah, I can talk to that. So what you heard me ask earlier was the situation. The traffic stop started with a turn signal violation. The officer involved then requested a canine within about 2 minutes of the traffic stop being initiated. And in the report, it said that this was a high crime area, and the person was driving a nice car. It was the allegation that was made by the community member. So it felt like the officer was within policy to make the stop. No arrests were made, but the underlying factor of why the the traffic stop continued was that there was a 2011 and 2013 drug possession charge that the driver had. But once they had, searched the vehicle and everything, the dog went around, none of the allegations were founded. And the dog, one of the allegations was that they made the dog hit, quote unquote, but it did not. No drugs were found within the vehicle and no one was cited at the scene. So we felt like they followed policy. It is one of those areas that I have concern for about, like, are we initiating traffic stops for the right reasons? Or, are we, pulling somebody over for a turn signal violation that leads to nothing is a really great way for that story to end. But we know sometimes those stories don't end that way, right? And that those traffic stops do, find drugs or find weapons or whatever. And so we had a long discussion about it, but in the end, we felt like the officer followed their policy.
So I think I appreciate that context. I mean, I think this brings to mind in terms of we've had a number of the cases, similar fact patterns that have happened that are within policy in isolation. But I think one of the challenges as board members, is the capacity to actually review and search all of these different cases to identify potential patterns. And so, I think that is one thing that I know is a charge and an ask of the DIG to look at broader patterns and practices. But I also know capacity is a real challenge. You're navigating cases, active cases, having to investigate and go through those. So then to be able to scale back, it takes a tremendous amount of resources and capacity to do a comprehensive review. And so it's not going to change the outcome of this particular case, but one hopeful parting piece of wisdom is that this board establishes some sort of working group, that doesn't just include board members, but potentially whether it's members of the public or elsewhere to participate in a working group or subcommittee, or subcommittees could do this, because we as individuals in our volunteer time do not have the capacity to look at all of these past cases to identify potential patterns. You all do not have the capacity or resource to do so, but I think there are folks on city council, folks and staff that could play a role in helping support that effort. So that would be my hope, that this board hopefully will take that action. But I think that will help address these types of incidents moving forward. Thanks.
I agree with everything you just said. But I think in this particular instance, looking at the footage will help us get an idea of, what happened, and even the more we look at footage, it's going to help us be better board members, because it's going to help the IG, it's going to help everybody. So I'm going to encourage the board to, when we have questions like this, look at the BWC, especially when it comes to domestic violence or anything like that. That's how we can find out what actually happened. So.
Committee, Crystal, myself, our prior committee, went down there a lot. And it isn't often that you have to go down there to the Inspector General's office to view BWC, but when you do go there, the investigators meet you there, and they explain the case, and you really get an insight as to what happened. And several times I absolutely changed my mind as to the situation. I think both Crystal and I changed our minds as to what really occurred. So, and we have access to so much information through the Inspector General's office. And I just want to say one quick thing. I went to a few NACO conferences and had the opportunity to view boards in other parts of the United States who do not have independent Inspector General's office. They review internal affairs. So they don't have what we have here. We truly are doing, this board is doing a great service for the citizens of the city of Columbus, because we have an Inspector General that is independent and does all of this investigation when the citizens complain, and then we have a board that reviews and makes recommendations. And the only thing, there's room for improvements, and through, those have been made, those have been made known to the Inspector General, and we have such a good working relationship that I think those will be worked on. Thanks for listening.
Okay, any other questions about those cases? Okay, we've got our open motion and second on all 6 cases reviewed by Committee 2. All in favor, please raise your hands. Any opposed? Any abstentions? Motion's carry. All right, Committee 3.
Committee 3 met and reviewed case 260013, 260016, 260037, 260041, 260053, 260105, and 260144. We did have one question, a follow-up question on the 260016. We were seeking clarification on whether there was an established policy or procedure for how CBD closes out runs that are not completed. In this case, it was due to the officers being redirected to a higher priority call. We did receive information back. Sorry here. And the information was there's no policy or procedure for how CBD closes out runs that are not completed due to the officers being directed to a higher priority call. The officers were on a stolen vehicle recovery run in this instance when a cutting stabbing run actually occurred, came over the radio, and the officers advised dispatch to put them on the new run. The dispatcher, we believe, should have put the stolen vehicle recovery run back on pending queue, because what happened in this case, because that did not happen, at the end of the night, they closed out the case, but the complainant did not get her car back for 3 weeks. So we were wondering about the policy, if there was any policy and procedure about that, because we just felt like had the dispatcher, and of course it was not on the officer so much, but had the dispatcher put it back in queue, maybe the complainant would have had her car back quicker than the 3-week time period. Did you have anything to add?
Yeah, I just wanted to get into the facts of that one just a little bit more, just because I think it illustrates why we had a question about this and why it might be something we want to highlight here. But the gist is that the officers, the plate hit on a flock camera that said this is a stolen vehicle. And then when he goes to confirm it, he tries to run it through leads, and it's not coming back, it's not coming back. And then that's when they're dispatched to the stabbing call. It turns out it's because, I think based on the facts we have here in the report, that it was because it was a Franklin County issue, Prairie Township, I think where the car was stolen out of, they didn't put it into leads in time so that the Columbus police would show up for their lead search. So then at the end of his shift at 6 a.m., the dispatcher is like, okay, do you want to go back to this vehicle? He goes, no, it's the end of my shift, which makes sense. But then it sort of just dropped the ball. So 3 weeks goes by, and this woman's car is just still, we know where it is. We already confirmed it was stolen through at least the flock camera, but not through leads. So we had the question of sort of, what policies and procedures apply here, and you answered that, and I appreciate that, Inspector General. You mentioned at the end of your email that you had advised the ECC of the circumstances, and you asked them to determine or sought to determine whether the dispatcher did anything wrong. Do you have any report back about that piece of it?
So we don't have anything yet, but we can reach out to see if it, again, was something that was on the dispatcher's side for not doing anything. But again, the good thing is what we did say is we didn't find a policy, so that is a good thing, even though if the board is looking like to say there is no policy making a recommendation that there is a policy that maybe CPD do that finding. But what I will do is when the next board meeting, I'll make a note to see when we follow up with ECC to see if that was something that the dispatcher was supposed to do and they did not do. I know a lot of times we do refer those over to ECC, but we don't always follow up. But we can definitely follow up to see if maybe that might have been an ECC policy. And
Yeah, I think we understood that they had to confirm if it was actually stolen or not. We understood that part. It's just the dropping of the ball at the end. You know, whether it was the officers' end of the shift or they put it back in queue for someone on the next shift to go back and look at it to confirm that. But yeah, that'd be nice if you could get back with us on that.
And then as far as it being a sort of ongoing policy discussion, maybe that's something, Chair Burns, we could put on the agenda as a placeholder, and then if we're ready to have that conversation, we could have it, or, you know, kick it a little bit more to, while we're still gathering facts about this case.
Absolutely. But Committee 3 did meet. Again, we reviewed cases and voted. We did agree with the findings of the DIG on all cases, and we moved to accept the findings.
Okay, may I have a second, please?
Second.
Okay, any other questions on those cases?
Just for clarification on that one case in particular that you just mentioned, what was the officer response in terms of what, you know, why that, who should have done something? Because it seems like there was not a policy that was found here that relates to that. But what was there a reason that didn't happen other than it being the end of the shift?
That was it. He was sent on another case, a higher priority case. That's why when that occurred, and they was waiting for it to, you know, confirm if it was on the stolen list or not. But when he was sent on the higher priority case, he went to that. By the time they was done with that, it was end of shift, and it was just closed out. And that was our take on it too. Should the dispatcher put it back in queue for someone else to do it? But clearly was no policy violated, but we just thought instead of finding her car that day, they found it, right? She didn't get it for 3 weeks.
Yeah, I'm curious that there's no policy around that. It seems like this would be a more.
Well, I think my question for Mr. Tobias is dispatch policy specifically civilian, or is dispatch policy governed by CPD? I can't remember, because I think we actually did have a training about the difference between
Yeah, I mean,
dispatch.
the dispatchers are civilian. Whether there's a difference off the top of my head, I'm going to say yes, but I don't know for sure. I can certainly look into that.
If you could, that would be
Yep,
helpful, because I think that would inform what sort of recommendation the board has the
Absolutely.
authority to make, and then kind of what that would look like.
That's great. Thank you.
Okay, so we've got open motions. Pausing, any further questions on those cases? Okay, seeing none, all in favor, please raise your hands. Any opposed? Any abstentions? All right, thank you all. I will just pause for a second. So we know that at least until the 11th, cases can't be distributed to committees and have our new members participate. I did send Ms. Brock some shuffling of committee members so that we don't have one committee that is all brand-new people. I think, Pastor Jones, you will see you've been moved to Committee 1 as chair of that committee, and then we're adding new people to fill in all the others. Okay? All right, next, going kind of into our more open, yes. Yes, gotcha. Yep, I gotcha. Going into more of our open topic, procedure policy review. I do know that we have a citizen who would like to speak to the board. And so similar to city council, we do have a 3-minute sort of statement time. So Mr. Melville, if you would like to take the microphone from Ms. Brock.
Hello. Where would you like me to go?
Oh, there's fine.
All right. Well, thank you. My name is John Belleville. I live in Clintonville. I do not represent any group. I'm here just for myself. Just my concern is with the quality of the investigations that the Inspector General's office has conducted. I've submitted several complaints, multiple complaints over the past couple years regarding misconduct, just little stuff, traffic violations, not wearing your name and badge number on your shirt. Had an incident where officer chose not to take action against an assault, which he witnessed. And for whatever reason, nothing happened. They didn't even investigate that. Even when you're presented with the proverbial 8x10 color glossy photos with circles and arrows on it, with with stuff on the back written on it, showing what it is. But it feels like nothing's happened. And I just feel that this board may be making conclusions based upon those incomplete or improper investigations. And I do ask that Inspector General's office review these reports, review these findings, just to make sure that they do address all the issues and that they do actually reflect true policy and reality. And if you have any questions, I'm here. Thank you.
Thank you, Mr. Melville. Does anyone have any questions for Mr. Melville?
I do. Thank you for your testimony. I'd be curious in terms of, as you've seen the Civilian Review Board operate over the last several years, what you talked about incomplete investigations, those types of things. Are there specific steps that you think we could be taking as a board or getting additional public input? What would you advise?
I'm not sure what the board itself can do. I'm sure it's more on the Inspector General's office, just to make sure that these are fully reviewed. One incident I just mentioned, an assault, captured on the officer's body camera. If the department would have reviewed that, nothing. They would have seen that and taken action on it. And also communication, kind of circling back, communication. I submitted a complaint. I got a call last week. Tried to contact the investigator. No response. The voicemail box is not set up. There's no way for me to contact the investigator as they requested.
Got it. Thank you.
And if you'd like me to demonstrate, I will right now.
Thank you. I mean, I think that I appreciate it. No further questions of mine and others. I guess maybe questions that I would direct, I don't know if I can direct it to the Department of Inspector General, just in terms of our understanding is that all cases go through your office and there's a process of then circling back after the investigation is complete with the complainant on the status, on the status of the investigation. Is that correct?
That is correct.
Okay.
All right. I will now turn it over to Board Member Younger, unless there are any other questions. for Mr.
I do
Melville.
have some more. I do have some more questions. But I think, so one, I appreciate your testimony. I do think and I'm glad we had the space for this public testimony, because through the 58 plus meetings that we've had, I think we've only had like 5 or 6 examples of public testimony for folks to step up and come in and speak. And I think that is, you look at different civilian review boards across the country, and there are more opportunities for public testimony. And so I encourage folks, if they have concerns, comments, to come up and speak to your board members, your Inspector General, to make your voices heard. And then I think it's important and incumbent on us to kind of follow up to make sure that process. I think we're talking about this data dashboard as an example, potentially to keep track of potential cases. But I think we can definitely think about ways in which we're communicating and ensuring that we have follow-up. So appreciate your testimony.
All right, I'm going to turn it to Board Member Younger.
At this point, there has been, there has been a situation in the media where the Columbus Division of Police was involved in the shooting of a 39-year-old Chantez, Chantez Loury, Loury, and this was after an attempted traffic stop. And that individual was shot and killed by Columbus Police. And I'm not certain if if a complaint has been filed, but we need to file a complaint within a specific period of time while the criminal investigation goes on. So we would like to do that as a board if a complaint has not already been filed.
So we'll have to make a motion. Is that the ask, Board Member Younger to make a motion?
I am making a motion at this time to have that.
Okay. That's similar to other high-profile instances in which a shooting death has occurred, and the board has made these recommendations with the understanding that should a criminal investigation also be occurring, then any board investigation or IG investigation is paused pending the outcome of that. Okay, so we've got a motion. Do I have a second?
Second.
Okay, we have a second. Any questions?
I just want to clarify. So is this a board-initiated complaint or a board-initiated investigation? How does that since it's board-initiated? I just wanted to get a sense of what that process actually is.
So it's board initiated. We asked the IG to do the investigation. Part of what's in our bylaws about it is that in the event of high-profile shootings in which we are not, as a board, yet aware of whether a complaint has been filed by a family member or someone else who has firsthand knowledge of what happened, we did not want the 90 days to expire without their rights being able to be preserved. And so we have, I think we've done it now on 4 occasions as a board when we've been made aware of an officer-involved shooting, how to vote to ask the IG to investigate. It's a board-initiated complaint. Okay, so we've got a first and a second. Any other questions or discussion? Okay, seeing none, all in favor of asking the IG to investigate that officer-involved shooting, please raise your hands. Any opposed? Any abstentions? Okay, motion carries. All right. For procedure and policy review, we did have an issue come up. I think it was brought kind of in conjunction between Dr. Ford and Board Member Fay about specifically BWC policy and then some municipal code and intersection between policies. And so I'm going to pause first and ask if any board members had the opportunity to look at both the municipal code section and the policy number for CPD since our last meeting. And if so, do we have any kind of takers on taking a initial draft of something if we would like to pursue proposing some amendment language or statute language?
Yeah, I'd be happy to take lead on that.
Okay.
I think what might be most productive is if I maybe would preview a little bit of what I'm thinking, just very briefly, and then just kind of circulate an email to the board saying, here are at least my thoughts, what do you all think? Here's potential language. Unless you think it'd be better to set up a committee now, or if we should go that route, I don't know what you think.
Yeah, and I'll just give a general word of caution about the emails going back and forth. If it's information sharing, I'm okay with that. Anything that's going to ask for input, thoughts, edits, I would reserve that for an open meeting, whether it be committee or regular.
Understood.
And I think and sadly, Dr. Ford couldn't make it to this meeting on very short notice, but I do think he also had an interest in participating. So I think if you and Dr. Ford, if maybe we can have one more board member who would be interested in joining that ad hoc committee, please let us know. And then that way, maybe then the 3 of you could work together on whatever the official wordsmithing of it. But feel free to give a preview of kind of what your thoughts are about.
Yeah, and maybe we could wait until next month when we have potentially 4 new members, if somebody else is interested as well.
Who might jump on, yeah.
Yeah. So a couple things quickly stand out. So just looking at the city code on this, 2107.01, specifically 2107.06, actually, there's this provision for when the police officer does not have to, or would have the discretion not to impound the vehicle and to not impose fees. And the provision provides that the officer would not have to, or has the discretion to waive fees essentially if the person whose car was towed is a victim of a violent crime or other special circumstances. So right there is, I think, a pretty broad net under which CPD could have a policy to set certain circumstances under which a vehicle that is impounded could have fees waived as to the owner when they go to pick up the vehicle. And just to backtrack quickly, this is about, the policy versus the city code about when vehicles are impounded, what is allowed under city code, and then how is that implemented through CPD policy. So as it currently stands under CPD policy, as I read it, there is sort of a allowance for waiving of fees if the vehicle was towed and impounded because of a medical emergency or because the vehicle was suspected to be stolen and turns out it wasn't stolen. In those two sort of situations, the fees could be waived. This is an area where I think there could be a more extensive list of categories where you might consider waiving the fees. In addition to medical emergencies, domestic violence situations, wrongful or mistaken impoundment. And then I think the key one would be when the owner is not really responsible for the conduct leading to the impoundment of the vehicle. This was, I think, the situation in one of our cases that kind of brought this top of mind to me, where a passenger who owned the vehicle had lent it to her boyfriend or partner who was driving without a license. She may or may not have known that he didn't have a license or that it was current. They still towed the car even though she wasn't arrested or, otherwise detained, even though she was right there and she could have just driven the car home. So those situations, I think we might want to think about making a recommendation of policy as to waiving of fees. The other thing I want to highlight is that in the CPD policy, which is 6.01, impounding and towing, there is actually a list of enforcement options that officers that's in this policy. And it sort of lays out, in order of preference, this is what an officer should consider doing when thinking about impounding a vehicle. And the first option is release to the vehicle owner, provided there's no legal requirement to impound it. Second option would be to park it in a legal location, secure the vehicle, and keep the keys, and then find the registered owner and tell them about it. And then the third option, after those first two, in order of priority, would be to impound the vehicle. So there's already built into the policy a preference to not impound.
Right.
So perhaps, I don't know if there is documentation of, when they do impound a vehicle, they have to say, well, I considered these first two options, but I bypassed them because of these reasons. Maybe they should be required to explain why they're impounding the vehicle and not releasing to the vehicle owner. That would be separate from saying, well, we're permitted to under city code, but here under your policy, why do you bypass the first two preferences and actually impound the vehicle, given the circumstances? So those are where my thoughts are kind of at. I can circulate an email just for information purposes about that as well, and then maybe we can see where interest grows from there.
I want to say something. I think this is just fantastic because I worked with the Public Defender's Office for so many years, and this causes so much so many financial problems for our clients in the Public Defender's Office, because one of these can just devastate a family. So this is, and looking at the prior two, that the officer could do, because I think sometimes it's just willy-nilly. So this is great. Thank you.
Thank you.
Yeah.
I would just add, so I appreciate the research and your work on this, Board Member Fahey. I think one of the things that I've seen just being a member of this board, just that's the capacity question, right, moving forward. I do think this is something where beyond just CPD policy, this does warrant, I think, involvement for city council. I know we've talked about potentially have represented, whether it's Councilmember Ross or others, Councilmember Remy, others to actually participate and engage. And I think, over the years, we've had kind of hit or miss engagement with council. And I think part of that is probably their want to have the board be independent as an organization, as an entity. But I do think that there are a number of issues that come up consistently, like what you've mentioned, that are a matter of city code. And then based on that city code is where CPD will have their policy that I think, would warrant a review of this. And we know, especially in these issues, fines and fees are a huge burden on communities and residents. And so I would just encourage maybe more formal engagement with council. So I know we kind of have meetings here or there, and sometimes they're in touch with DIG or the chair, but I do think maybe having it 2 times a year or something where there's regular engagement with council, I would highly recommend that this board moves in that direction, because we've got a lot of folks who are eager and willing to help and support on this, but everybody's got competing priorities. And so until we formalize that, I worry that these ad hoc committees will just be ad hoc on their own. So that would be a step that I hope the board takes moving forward.
Thank you, Board Member Fay. And I'll email Dr. Ford just to be sure he's good with being on another another committee. All right, so we kind of pushed forward to next month the bylaws apparels discussion. We also, until Dr. Ford gets back, we'll revisit BWC policy activation time, since that was his request as well. Any other policy issues that we'd like to put on our upcoming agendas for discussion? Okay, seeing none, I'd entertain a motion to adjourn.
May I, because this is our last meeting, I would just like to say thank you to the board, to Chair Burns, to our Inspector General, Mr. Tobias. It's been a real privilege to work together with you, and over the 5 years that we've been doing this, I think the board and the IG's office has accomplished a great deal for our city. It's not a perfect system. We just heard from one of our citizens that there's still bugs to be worked out, but putting something in place, I think we've had an opportunity to have an independent group of folks who are not associated with the police reviewing police actions. I hope the police feel that we've been fair arbiters, and that some of the recommendations have turned out better than the police hoped. And I hope that the city feels that this is a great start, but it's been a privilege to serve. So thank you for the opportunity and for working together. I feel privileged to have served. So
Thank you, Pastor Nathan.
It's absolutely been a privilege, and I think we are doing a lot. And sir, I hope that your questions get answered. But I've loved seeing the new members that are coming on, because from what I've seen, we are definitely leaving in good hands here. So, yeah, it's been great and a total privilege. Thank you.
Thank you, Board Member Younger.
Yep.
Well, thank you all. It's been a good run here on the board. A lot of new faces, really excited. It's been just an absolute pleasure to work with you, IG, with Attorney Tobias, Stephanie, the entire team. Has just done a tremendous amount of work, and I think our board has just been great to work with. Don't always agree, which is actually a good thing. I think it is good to have healthy debate and conversation, and really never from a place of critique for an inability to do the work or an unwillingness to do the work. And I think the DIG's office in particular, especially the investigators who do this work, it's often a thankless job, but are tremendous, starting from scratch out of an entity. So it's not going to be perfect, as we've heard, but I think we've got to be more comfortable with the spaces of opening up room for conversation, critique, and then figuring out what we can do better. And I think you all have, your office has been really open to listening and seeing what can change and go differently. I hope this board gets this data dashboard. I hope we can make it happen. There's a few steps there. But the one thing I'll just say, like a word of advice, unsolicited, of course, but I've got the mic, which is, the 5 years has gone by, it has flown by, right? It really has in many ways. But in terms of when you're working with the bureaucracy that is city government, that is review boards and all that, things can really churn and move very slowly. And so I do think, this point I made about bringing in outside entities as well to help support and build capacity, not just for the DIG's office, but for the board, is really important to get more urgency from city council, from the mayor's office on some of these issues. Because even if they agree that things need to change and need to happen, some of this stuff can take years to move. And so I don't want that to frustrate anybody, but just it's what I've seen. And I don't want that to be mistaken with a failure of the board to do its job or the failure of the DIG to do its job. It's just figuring out ways to continue to ping review board, talking to city council, talking to the mayor's office to say, hey, are we working on this? So it's not just on the DIG's office as well. So appreciate it. It's been an honor to serve. Really excited for everybody who stepped up to be a part of this board. Thanks, everybody.
Thank you, Board Member Strickland. Yes.
I know I haven't had a chance to speak, but let me just say, really appreciate all of the work that all of you, the board members that are leaving, have done. I said in the beginning when I took the job, I actually went online and I watched all of you, the background, how you talk, your passion. And that was the reason I even applied for the position. So again, I'm having the ability, and hopefully the board members don't mind, I'm trying to do an exit interview with some of the ones that are leaving to get feedback just, for the board and our office. And some of them have shared some really good information. And hopefully that's something that going forward I can kind of share, because we all want to do better. I mean, that's the reason we're here. So again, appreciate all the work that you do, and thank you so much. Thank you.
All right. Well, now, unless anyone else would like to speak, I would entertain a motion to adjourn.
Motion.
Okay, may I have a second?
Second.
All right, all in favor, please raise your hands. So moved, adjourned. Thank you all.
Bless you.
Yeah, you too, Rich. Hopefully I'll get to run.